This lesson focuses on the Americans with Disabilities Act. Within this lesson, we will start by discussing the Rehabilitation Act of 1973, the Individuals with Disabilities Education Act of 1975, and then dive into the Americans with Disabilities Act of 1990, focusing on Title I, II, and III, and then we will close with defenses to disability discrimination. Before we discuss how legislation has evolved to protect and provide accommodations for individuals with disability, I first wanted us to have context about the prevalence of disabilities within our country. On this slide, you will see data from the CDC that reports an estimated 61 million adults in the United States. So that's about 1 in every 4 adults live with a disability that may affect their daily life and functioning. Now, while many disabilities affect one's physical mobility and can be seen, such as a physical disability. So on this slide, we see about 13.7% of adults having a disability that affects their mobility. There are a number of disabilities that are not visible that may affect one's cognition, their ability to live independently, their hearing or their vision, or their ability to engage in self-care. And so disabilities are both visible and not visible and affect individuals who are engaging in our industry. People who are working in the sport industry or consuming the sport industry all may be impacted by a disability. And so as sport managers, it is our responsibility to make sure that individuals with a disability have full and equal access to all programs, services, and accommodations. When considering our industry, unfortunately, historically, full participation and equal opportunity in sport and recreation services have been a significant challenge for people with disabilities. This can often be attributed to physical barriers to participation, such as inaccessible sport and recreation facilities, as well as a general lack of understanding of the needs of people with disabilities and how we can best accommodate them. And so an emerging and important priority in sport management is to proactively provide a barrier-free and inclusive environment for all people with disabilities. And now in looking back at the history of legislation that has provided protections and provisions for individuals with disabilities, we can look all the way back to the 1970s. Now, prior to 1970, sadly, people with disabilities were often treated like a nuisance, like an interference. And it wasn't until the Rehabilitation Act of 1973 that we started to see protections for individuals. So prior to 1970, particularly in the school system, was where we were seeing a lot of problems. Children with learning disabilities were being denied access to many public school systems and services because it was thought that their presence would interfere with the learning environment of students without disabilities. And so in order to address this discrimination that was occurring in the school system, Congress enacted a federal law designed to protect the rights of individuals with disabilities and in programs and activities that receive federal financial assistance from the US Department of Education. And our particular focus right now is on Section 504. And under Section 504, a qualified individual with a disability cannot be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance by reason of their disability. So essentially, it prohibits discrimination based upon one's disability. And for a plaintiff, if you are a student, most likely your parent would be filing on behalf of you since you are a minor. And as a plaintiff, if you were experiencing discrimination in, we'll say, the school context, and for this particular legislation, you would need to prove these 4 elements. So first, the injured party would need to prove that they are a person with a disability. And to prove that, you either need to have a record, so documentation of having that disability, that substantially limits your major life activities, or you just need to merely prove that you are one who is regarded as having a disability or impairment. And we'll talk about that a bit more in a moment. Next, you need to prove that you are qualified for the program or activity, which means that with or without reasonable accommodation, you are able to meet all the necessary requirements to participate in the program or activity safely. And there are a number of different ways that you can provide reasonable accommodations to make these programs and activities inclusive, and to allow individuals with disabilities to participate. And we'll also talk about that in another moment when we talk about the ADA. The third thing that the plaintiff must establish is that they were excluded from participation in this program or activity solely by reason of their disability. So they need to demonstrate discrimination because of their disability, even though they were qualified to participate. They could safely engage with or without reasonable accommodation. And then lastly, if you are filing under Section 504, you would need to demonstrate that the program or activity is receiving federal financial assistance, because that is who is primarily subject to this legislation. So the Rehabilitation Act, Section 504, focuses on prohibiting discrimination. So I wanted to draw your attention to that as we transition to our next legislation, which is the Individuals with Disabilities Education Act. IDEA is the acronym that's often used, which was enacted by Congress in 1975. So while Section 504 of the Rehabilitation Act focused on prohibiting discrimination, IDEA focuses on providing accommodation and providing services. So we're starting to see Congress expand not only the rights of individuals with disabilities, but also the provisions that are given to them. So IDEA is an education act that is designed to provide federal financial assistance to assist state and local education agencies to guarantee special education and related services to eligible children with disabilities. So this act really focuses on making sure schools have the necessary resources in order to provide the services that students with disabilities need. IDEA requires public schools to make available to all eligible children with disabilities a free, appropriate public education. So you might see FAPE, that's a common acronym used when discussing IDEA. So this act is providing a free, appropriate public education in the least restrictive environment that is appropriate to their individual needs. And by least restrictive environment, the goal is to have students with disabilities engaged with students without disabilities. The goal is a truly inclusive environment. IDEA, in order to provide these services, IDEA requires public schools to develop what's called an individual education program for each child that qualifies who has a disability. As you'll see on the bottom of this slide, this act is a provision for children ages 3 to 21 who meet one or more of the 13 disability categories. I gave you a couple of examples on this slide of disability categories. So autism, deafness, deaf-blindness, hearing impairments, multiple disabilities, orthopedic impairments, health impairments, serious emotional disturbance, learning disabilities, speech or language impairments, traumatic brain injuries, visual impairments, all of those are categories of disabilities. And in order to qualify for this individual education program, you must go through a pretty comprehensive evaluation. And I'll talk a little bit more about that in the next slide. However, the IEP, going back to what that is, it is a written statement that is outlining all achievable educational goals and objectives that the individual student is going to pursue. It also, most importantly, outlines the accommodations and related services that the public school is going to provide. So it almost acts as a contract, indicating all accommodations that will be provided. And if athletics is included in a student's IEP, this is an important thing to note. It becomes a legally federally protected right. Typically, athletics at the interscholastic and intercollegiate level are considered a privilege and not a right that you have legal protection over. But if it is included in your IEP, it actually does transform into a legally protected right. So you have even greater protections for access to athletic programs and services. I wanted to include this slide. I thought was a really nice graphic that highlights different characteristics of IDEA and pointing out a few things. Under the least restrictive environment, you'll see that the goal is to have students engaged with other students that do not have a disability to the greatest extent possible. So the goal isn't to have students with disabilities have their own programs, their own activities. It would be like a student who wants to participate in interscholastic athletics, and rather than allowing them to participate on the school athletic teams, it would be, creating a completely separate adaptive sport for only individuals with disabilities. We're not trying to create separate but equal. We're trying to create inclusion through this act. And the evaluation that takes place to determine whether a student is eligible for an IEP, it is a partnership between the school and the parent. So the parent, you'll see, have its involvement throughout the process in about having the student be evaluated, determining the services for the student. All of these services are kept confidential, but are really just supposed to help students have full access to education and all extracurricular activities, and also help them transition from school to eventually the work environment. And I thought this fact was interesting, if a student is not able to receive services under IDEA, because IDEA does limit qualification to 13 disability categories, they actually can file under 504. So section 504, they can try and recover some of those services and accommodations by that act. So I thought that was pretty interesting. that reviews a bit of the history of legislation as it pertains to individuals with disabilities. But we're really going to focus on the Americans with Disabilities Act, which was enacted by Congress in 1990. And the purpose of the act was to extend many of the provisions of the Rehabilitation Act and IDEA to the private sector. So while the Rehabilitation Act and IDEA largely focused on the public sector, particularly the school system, the ADA was enacted to provide provisions and protections for people broadly, including the private sector. So it is a national mandate. So the purpose of the act, there's actually a few purposes I wanted to review. First and foremost, it's to provide a clear and comprehensive national mandate to eliminate discrimination against individuals with disabilities broadly. The act is there to provide clear, strong, consistent, enforceable standards that address discrimination against individuals with disabilities, and to ensure that the federal government plays a really central role in enforcing the standards established in this act on behalf of individuals with disabilities. So once again, we're really trying to eliminate discrimination nationally that people with people with disabilities face on a daily basis. So the provisions, the protections are greatly expanded under this act. Now, for a plaintiff to win a discrimination case under ADA, they need to prove that they are a person with a disability, that they are a qualified individual with a disability, and that they were unlawfully discriminated against because of their disability. So we first need to define, what does disability mean and what does a qualified individual with a disability mean? So the term disability for the purposes of ADA means that an individual has a physical or mental impairment that substantially limits one or more of their major life activities. And by physical or mental impairment, that can be any physiological disorder or condition, a cosmetic disfigurement, an anatomical loss affecting one or more of the bodily systems. It can really be a range of impairments. But the focus is that this impairment affects a major life activity. And a major life activity are functions including self-care, so caring for yourself, performing manual tasks, even functions as fundamental as walking, seeing, hearing, speaking, breathing, learning, working, many major life activities that you and I may take for granted. Those individuals with disabilities are impacted, experience unique challenges. So it's having an impairment, having record of that impairment, so documentation, for example, or potentially being regarded as having such an impairment. I find this third one to be really interesting because even if you don't have a disability, if you are regarded and treated as having a disability, you can still experience discrimination because of this alleged disability. And so the ADA gives protections to you as well. An example of this I thought was really helpful. My boss at a previous institution was visually impaired, and when going to a sport game, he would receive assistance to get to his seat with his support dog Kate. And when a usher would be walking my boss to his seat, they would speak to him as if he was a child, talking to him in slow, a slow manner, speaking really loudly as if he had a hearing impairment, and using simple and small words like he had a learning disability. For some reason, based upon his visual impairment, the usher would presume a number of other impairments and treat him as such, which is a discrimination, being regarded as having other impairments. His story was just really powerful to me in checking my own presumptions when interacting with others. So, if you are regarded as having an impairment, you also have protections. I'm just going to jump to this slide and come back to the previous slide just to show you that there are so many different types of disabilities that are protected under the ADA. So, I mean, there are ADD and ADHD disorders, as well as learning disabilities. Now, disabilities that we can see would be physical disabilities, but there are so many disabilities that we are not able to see, such as brain injuries or um, blindness. So it could be low vision, or you're legally blind or totally blind. There are psychiatric disabilities and speech and language disabilities, deaf and hard of hearing. So there are so many different disabilities that can receive protection under the Americans with Disabilities Act. Now, going back to this previous slide, not only does the plaintiff, if experiencing discrimination, need to prove that they are an individual that either has a disability or is regarded as having such an impairment, they also need to demonstrate that they are a qualified individual with a disability. And what that means is that with or without reasonable accommodation, they are able to either perform the essential functions of a employment position, or they are able to meet the necessary requirements to safely participate in a program or an activity, or meet the essential eligibility requirements to receive a particular service. So, a qualified individual with a disability is one who has a disability and, with or without reasonable accommodation, meets all necessary requirements to receive some type of program, service, benefit, something like that. And we'll talk more about that as we discuss the individual titles. Moving down to the ADA titles, there are 5 different ADA titles, but these titles have emerged over time. I found this infographic that details the history of the ADA really fascinating in terms of when different titles were created and how the ADA has evolved over time. Of these titles, Title I, Title II, and Title III are of greatest relevance to sport. And so those are the ones we are going to focus on, that focus on the employment context, public services, and then public accommodations provided by private entities. However, there is also Title IV, which focuses on telecommunication and telephone services. And then Title V, it's a bit of a catch-all. It involves retaliation or coercion, non-discrimination and service benefits, and then like attorney fees. It's just a lot of different things in Title V. And I just wanted to highlight 2008 and 2019, because these are some key changes in the ADA that have happened that impact us as sport managers. So, broadly speaking, the ADA protects individuals with disabilities from discrimination based upon their disability. However, what we were finding in the court system is that greater weight was being given to the defendants than the plaintiffs in cases of discrimination, because courts were adopting a very narrow view of what is disabled. Like, what does a disability really mean? For example, courts would be denying provisions and accommodations for individuals with disabilities because they were considering the impairment to not be serious enough, right? The plaintiff's condition doesn't quite qualify as a disability, so you don't get protection under the ADA. So the courts were just adopting a really narrow definition of what does it truly mean to be disabled, and very few individuals were receiving protection under the ADA. So in 2008, there was a amendment to the Americans with Disabilities Act. And this amendment was in response to just a number of decisions by the Supreme Court that was interpreting this definition of disability really narrowly. And so the primary purpose of this amendment is to expand the interpretation of disability. So we're still retaining the language of disability, but it changed how it is to be interpreted, just really broadening the language and the interpretation of disability so that more people and different types of disabilities would be protected under the ADA. And then in 2019, we saw another change in the ADA. What we were seeing is more and more lawsuits filed for websites and apps not being accessible for individuals with disabilities. For example, back in 2016, there were roughly like 262 cases citing that businesses, websites, and applications were not accessible. By 2019, that increased to roughly 2,200 lawsuits specifically about website accessibility. So we're seeing greater and greater attention and issues with the accessibility of businesses' websites. They might make their programs accessible, they might make their facilities accessible, but they weren't making their websites accessible. So there was a really critical Supreme Court case back in 2019 that identified the responsibility of businesses and managers to make sure that their websites and apps are accessible. Just a little juicy nugget of the Supreme Court. I found it so interesting. It was a case where the plaintiff was a man with a visual impairment, and allegedly Domino's, so the pizza place, violated his rights under the ADA because the website and mobile app were not accessible to him because of his visual impairment. So the website did not work with his screen reading software. He couldn't order pizza, and he asked for an injunction forcing Domino's to comply with website accessibility standards. And though originally the court determined the court dismissed the plaintiff's complaints, this actually ended up being overturned. So the appellate court and then with the Supreme Court both determined that accessibility should include websites and apps. So that's kind of the most recent, I would say, advancement or progression of this legislation that relates to all of us. Let's focus in on the individual titles and how they pertain to the sport industry. For Title I specifically, which focuses on the employment context, it is enforced by the Equal Employment Opportunity Commission. Title I is an anti-discrimination statute that requires that individuals with disabilities be given the same consideration for employment that an individual without disabilities would be given. Now, employers that are under or that are subject to Title I are those that have 15 or more employees. And so businesses that do fall within the scope of ADA are required to provide reasonable accommodation so that an individual with a disability may perform the required tasks of their job. Now, When it comes to discrimination and accommodation within the employment context, we're talking about, the application and interview process, hiring, job assignments, job evaluation, promotion, termination, compensation, training, disciplinary action, service opportunities, conditions of your employment. We're talking everything related to the employment context if you weren't picking up on that. Uh, and so under ADA, it requires that businesses provide reasonable accommodation. This is any modification or adjustment to a job or the work environment that would enable a qualified applicant or employee with a disability to participate in the job process and perform the essential job functions. Reasonable accommodations that you can see at the bottom of your screen often include facility access, restructuring job tasks, modifying work schedules, potentially providing readers or special computers, interpreters, all examples that you can see on the graphics on this slide. Now, reasonable accommodations are required unless they would create an undue hardship on the employer. So, an undue hardship is really any action that would require significant difficulty or expense. And so the courts will consider, the nature and cost of the accommodation and weigh it against the overall financial resources of the agency, the size, budget, profitability of the business, and the potential financial impact of the accommodation. And so they'll weigh those against each other to see if it would be considered reasonable. But a few examples, or actually, here are a few examples of what would be unreasonable, just so you have some context. Eliminating an essential, important job function from a job position would be considered unreasonable. Having lower production standards for one employee compared to another employee would be unreasonable. Let's see. Making arrangements that just conflict with the company's seniority system would be considered unreasonable. Having to provide specific items for daily activities that are of a great expense would be unreasonable. Those are just different examples, but most accommodations, which we'll talk about, are reasonable. Under Title II, the focus is on public services. And just so you know, the Department of Justice's Civil Rights Division is responsible for enforcing Title II and Title III of the ADA. So it's under a different administration. And under Title II, public entities, so those are really any state and local government or their instrumentalities, think like state actors, think along those lines. Any public entities must give people with disabilities an equal opportunity to benefit from all of their programs, services, and activities. So when we're thinking about the sport industry, we're really focusing on, community sport and recreation and public schools and their athletic departments. Now, if a athlete is, so public schools, colleges, athletic associations. Okay, if an athlete is experiencing discrimination based on their disability, they would need to prove that they are an individual with a disability that is otherwise qualified for the activity, and this is with or without accommodation, and they are being excluded from athletic participation solely because of their disability, and they're being discriminated against by a public entity. Because once again, Title II really is just over the public sector. And I wanted to give a couple of examples on this slide of individuals who have a disability and are qualified. At the very top of this slide, you will see high school runner Paul Scott, who is visually impaired, and with a reasonable accommodation, which is Rebel Hayes to his right is a guide runner, is able to safely participate in running events. So cross country in this picture. So with an accommodation is a qualified individual who does have an impairment and should have equal access to all athletic programs, activities, and services. And then in the picture at the very bottom, you will see Shaquem Griffin. Shaquem Griffin is or was a star linebacker at the University of Central Florida. He was drafted to the Seattle Seahawks along with his twin brother, Shaquell. But as you can see on this picture, Shaquem is missing his left hand. It was removed when he was 4. But ever since that surgery, he was engaged in competitive football. And, even with this physical limitation, does not require accommodation and obviously is a very, very successful athlete. So I just wanted to emphasize that individuals with disabilities, in this case, athletes, sometimes they will require reasonable accommodation and are able to effectively participate in the athletic event. And they also may not require accommodation. So it is not up to us to make any presumptions, just provide equal access to programs and services, and then provide those accommodations where needed. The last title that we are going to discuss is Title III, and Title III will focus on sport, recreation, and play facilities. And so often, Title III is one of the biggest areas of concern for the sport industry. Now, Title III requires that all privately operated non-residential facilities, so these are places of public accommodation, facilities operated by private entities whose operations affect commerce. It requires these facilities to be accessible and usable by individuals with disabilities. So it requires equal access to all the goods, services, privileges, and advantages of those facilities. An example of what discrimination under Title III might look like would be providing different services or benefits to people with disabilities that are provided to able-bodied patrons. So a case, for example, that I was reading is about the use of jumbotrons and making sure that all communication is accessible through closed and open captioning through those jumbotrons. So those who are hearing impaired want to have access to what the officials are saying, and they want to have access to the words of the music lyrics and announcements and in-game promotions. They want equal access. So that would be kind of an example of an area of potential discrimination under Title III. Title III has particular priorities in regards to what private entities and businesses should focus on. The first is an accessible approach and entrance. So once again, we're really focusing on facilities here. So people with disabilities should be able to arrive on the side of a building, approach the building, and enter that building freely as everyone else would. You should have a safe route of travel that is accessible for everyone, including individuals with disabilities. So things such as ramps and handicap parking are really important for priority 1. Priority 2 is access to goods and services. And ideally, the layout of the facility should allow people with disabilities to obtain all materials or services without assistance. So in your stadium, do you have concession stands? How can individuals who may be physically impaired access that good and that service, hopefully without needed assistance? Do you have seating that can accommodate wheelchairs so that a spectator can access the game? The third is access to restrooms. So that is a huge priority because it is a major bodily function for all humans. And so when restrooms are open to the public, they need to be accessible to people with disabilities, which is why we'll always see a handicap stall that should be available. The restroom should, the door should be able to accommodate a wheelchair. The sinks should be able to accommodate someone um, who is physically impaired. And then the last priority is really any other measures necessary. So any other amenities, this might be like drinking fountains or public telephones, whatever other amenities are provided, they should be accessible to people with disabilities. So here on the screen, you'll see this restroom sign that shows that they would have a handicap stall. And then there's Braille for those who may be visually impaired that is identifying what the room is. Below, you will see an example of the measurements for protruding objects and the height that they need to be so that someone who is visually impaired um, who might need to use, a cane to identify where they're going, where there are protruding objects. It really just gives those dimensions for how to construct the facility to be safe so that someone could move about the facility safely. There are a few defenses to discrimination for us to consider. Now, we've already brought up undue hardship, and I wanted to add a little bit more context here. Undue hardship is a viable defense for ADA Title I, which is the employment context, or Title II, which is public services. It doesn't exactly pertain to Title III. We'll also talk about Title III in a minute. So undue hardship, once again, it's focusing on any action that requires significant difficulty or expense. And so courts will examine the nature and cost of the accommodation required, and then the expense that would place on the business. But they'll also consider, well, what resources does the business have? How large is the business? What would the overall impact be? Under Title II, the public entity is required to make reasonable modifications unless that service provider can demonstrate that doing so would either be an undue hardship or potentially fundamentally alter the nature of the service, program, or activity provided. So I wanted to highlight a couple of graphics on this screen. First of all, research shows that the majority of accommodations requested from individuals with disability have zero cost. So undue hardship is rarely a viable defense. And as you can see, when there are accommodations with cost, the median cost is $500 one-time cost. I just really wanted to draw your attention to, we should make all efforts to make reasonable accommodations. Often we'll see accommodations be unreasonable when it comes to adjusting the infrastructure of a building. Maybe you can avoid that and focus on other ways to accommodate an individual, such as if someone has a physical impairment, their office space is on the first floor. If you don't have an elevator in an old building, or you allow a service animal, or there are so many ways to accommodate without incurring a large cost. And then when it comes to fundamentally altering the nature of what is offered, we had previously discussed what would be unreasonable in the employment context, such as lowering production standards for someone with a disability versus someone without a disability. But we'll also see this in Title II when it comes to athletics. If you need to fundamentally alter the nature of a sport in order to accommodate an athlete with a disability, you do have a viable reason to not accommodate, and that could be used as a defense. On the screen, you'll just see an individual playing wheelchair basketball. Now that's an option, is to create an adaptive sport for individuals who cannot accommodate. But when it comes to athletes who are requesting to participate in your school's sport, for example, um, ideally, we are to pursue inclusive, universal design for our programs. The best practice standard is to provide full equal access to those athletic opportunities. But you must consider the safety of the individual and whether they are qualified individual with a disability, whether they can participate safely. You are not required to fundamentally alter the nature of the sport in terms of changing the rules. For example, changing the requirements. You know, if you have a tryout, this like changing the standards for one athlete as opposed to the rest of the team, that would be considered unreasonable. But there are so many ways to provide reasonable accommodation. I was reading a case the other day of an athlete who was hearing impaired, who was a wrestler and had a translator stand outside the mat and follow the wrestler in his line of sight so that they could translate any of the calls of the official, for example. So there are just so many ways to provide accommodations to increase access for individuals with disabilities. And then this last defense on this slide is a direct threat. And I want us to focus on this bottom picture for the direct threat, which we often see in relation to Title III. So a direct threat exception can be raised as a defense when there is concern about the health or safety of others, given the nature of the person's disability or due to the auxiliary aid that a person uses, such as a wheelchair. A direct threat is often an issue in the context of emergency evacuation of people with disabilities. And so when you see in stadiums accommodations for individuals who are wheelchair bound, for example, like on this picture, you'll see a area for that individual to sit and watch the game. You'll notice that often there are not places for individuals with a wheelchair to sit courtside, for example, because there are concerns regarding the evacuation of that person that efficiently and their safety. And so in these types of situations, safety of the individual with a disability and safety of those around them, can you efficiently evacuate people from a facility, will be considered. And so sometimes, unfortunately, we're not able to provide full and equal access to, an experience such as a sport event if it may create a direct threat to that individual or the individuals around them. So the placement of handicap seating is, I would say, one of the best examples that I can give you here. And my boss, who I had mentioned previously, who's visually impaired, so he requests accessible seating so that his service animal Kate can join him. And he was also sharing frustrations because he has to pay an upcharge for accessible seating, but he doesn't even have access to court seating because that's not provided because of this direct threat exception. And it's just, he's given me a lot of helpful insight over the years. And then lastly, a defense that pertains specifically to Title III is in regards to stadium accessibility requirements. Now, I do want to point out a resource. I'm going to share a different screen briefly. You'll see here that there is a very comprehensive guide to ADA standards for accessible facility design. Now, latest it was updated was back in 2010, but this is a 200-page document that goes over all of the ways to make a facility accessible. And if you scroll, I'm going to scroll down to the middle. Very comprehensive, if you can tell. You scroll, you'll start to see they are extremely specific about the dimensions and the construction and the design necessary to make facilities accessible. So it is a very detailed document outlining how to accommodate individuals in a facility. Let's go back to our PowerPoint. And I just wanted to clarify the limitations of this accessibility standard. So, because the ADA was enacted in 1990 and Title III a little bit later, buildings and facilities that were constructed prior to 1993 are not required to be in full compliance with ADA accessibility requirements, understandably, because the legislation hadn't been enacted yet. These existing facilities, Title III merely requires the removal of existing architectural barriers where it is readily achievable, meaning without very much difficulty or expense. So if you have a building that was built prior to 1993, there is an expectation that you will remove physical barriers for individuals with disabilities where it's readily achievable, but you are not held to the full standard and compliance of the ADA. However, if your old building was renovated after January 1992, it means that all renovations must be readily accessible and usable by individuals with disabilities to the maximum extent. So, any alteration, expansion, renovation to your facility, that piece must fully comply with ADA accessibility requirements. And by alterations, we're talking about major renovations, just so you know, not like routine painting or decorating or things of that nature. And then if it is a new building, so built after January 1993, once again, those are just required to be in full compliance. And so the reason why this is listed under a defense is because if a building or facility was built prior to this time frame, you could articulate that as a defense and reason for why your facility is not fully accessible. And that is the last defense. And I wanted to leave us with this one thought. When considering sport, I really appreciated this graphic because there we are able to provide full access to sport experiences, sport services, either with no modification or with minor modification. And even if we're not able to accommodate athletes in on teams with individuals with other disabilities, there are also ways to increase our programming to provide sport services to this population by creating adaptive sports for people with disabilities, integrating individuals with disabilities into other roles within our sport team or organization. There's so many ways to be inclusive, and I really strongly encourage you to take a moment to reflect upon how we as sport managers can provide full access for all people with disabilities. And we are going to close on that note.